Okay, so again, this is People of the State of Michigan versus Matthew Muller, docket number 19-70FH. This is the time set for hearing on a motion to terminate or modify probation. And could I have appearances first for the record?
Thank you. Sarah Polda, Assistant Prosecuting Attorney, appearing on behalf of the people.
Good afternoon, Your Honor. Kurt E. Kraus on behalf of Mr. Mueller.
Okay, thank you.
Good afternoon, Your Honor. Mary Chartier on behalf of Mr. Mueller. He is appearing by video.
Pardon me for stepping on you there. And it's Mueller, not Muller. I recognize that. Okay, Mr. Kraus, your motion. You want to go ahead?
Yes, thank you, Your Honor. Very briefly, Mr. Mueller seeks the court's permission to terminate his probation a bit early. As we've detailed in our motion, Your Honor, we believe Mr. Mueller is an ideal candidate for early discharge in any event. I want to emphasize he's completed more than 20 months of the 24 months that was part of that order without any violations, and he's completed all of its requirements, including the domestic abuse follow-up program, a copy of the certificate of completion, which we provided to the court and copied to Ms. Polda yesterday. I want to point out from that from the facilitator's notes are very positive, indicating that Mr. Mueller was both very attentive and active in that program, took full responsibility for his abusive and assaultive behavior, and that he was honest and thought-provoking in his responses to the videos. Additionally, he gained the ability to better understand his emotional triggers, expressed his desire to manage his emotions more effectively, and that he exceeded 26 weeks in the program. So clearly, from that standpoint, Mr. Mueller has dedicated himself to once again becoming a law-abiding and productive member of our society. So he's very committed to that, Your Honor. And that's really apart from what brings him before the court more specifically today. But part and parcel of his efforts to become a better and more productive citizen is and has been his commitment to his employer and to his attendant job duties. And to that point, the reason for Mr. Mueller's request is really based on his need for international travel as it relates to his ability to perform his job duties and to contribute to the success of collaborative supply chains. The need is critical for his success and the success of the employer. Indeed, the ability to travel internationally is critical enough that Mr. Mueller retained us, even though he's a mere 3 months away from successfully completing the entire term of the probation. We know that international travel is open for business to Europe and other continents. And given the needs of collaborative supply chains customers, Mr. Mueller felt that this was an appropriate time to request the termination. And I also want to emphasize, Your Honor, I know that Mr. Mueller certainly appreciates the court's previous modification to allow him to travel out of state, and he has successfully adhered to that new term, as well as obviously to the original terms of the court's order. And I just say, I think it bears noting that after the past year, under the strictures of the pandemic, it's apparent that while Zoom conferences have been a safe alternative, they are not a substitute in that context in terms of being able to work with and really understand the needs of customers, particularly those overseas. It's not a substitute for actually meeting with clients, breaking bread with them, again, to learn more directly about them and their business endeavors, and really to build the kind of trust and partnerships that both collaborative supply chains and Mr. Mueller needs to do. And again, this is particularly important for businesses with overseas clientele. So with that, Your Honor, unless the court has any questions, I'd respectfully request that the court grant our motion to terminate Mr. Mueller's probation at least 2 months early.
All right, thank you. And Ms. Polda, I'll turn to you for either a victim's statement or the people's position.
Thank you, Your Honor. We did attempt contact with the victim's mother in this case. She's been the person we've been in contact with as it relates to this case, sadly through no fault of her own. This case has been at her forefront for the last couple of years since it happened. And as we know, the victim in this case did pass away from an overdose that the victim's mother does attribute to the abusive relationship that the victim had with the defendant. As Your Honor knows, it's in your discretion on whether or not the court decides to terminate the probation early. I would like to note that the new statute regarding early termination would not allow this type of a charge to be discharged. However, from what I can tell and based on the brief from defense, without retroactively applying the new statute, it looks as if this charge would be dischargeable under the old statute that was in place at the time of the plea and the sentence. I would like to just note the position of the victim's mother. She was very upset about the defendant essentially getting, in I guess not so great words, a sweet deal on this case because her daughter had passed away. He was provided a jail sentence that allowed for him to be released early with the statutory credit. And she noted in her victim impact statement on behalf of her daughter that back when her daughter was still alive, the defendant's boss, who I believe is the same person who wrote a letter to the court indicating the need for the defendant to be released early so he can do the international travel. She indicated that that person had contacted her daughter by telephone daily, sometimes more than once a day, detailing, why the case shouldn't go forward and how the defendant is really needed at work and just trying to put that pressure on her. So to provide a letter to the court indicating that he should be released early is just another slap to the face for the victim and her family. I don't think that it's sincere. I think that he was part of the problem and the enabling of the defendant to believe that he could get away with whatever he wanted because he has a good job. So because of that and because of the victim's stance on this particular defendant, I would ask that Your Honor deny the request for early termination of probation.
All right, thank you.
Can I respond briefly, Your Honor?
Yeah, briefly, Mr. Krause.
Yeah, just very quickly, Your Honor. I think I just want to respond that first of all, Mr. Mueller has done everything that he was required to do by the court. There's no question about that. I cannot speak to what I believe it's Mr. Pretzel that Ms. Pold is referring to. I can't speak to that, but I will say that I think that's, and I realize we're not in trial, but it's sort of hearsay upon hearsay. And with all respect to the mother, and I empathize greatly and sympathize greatly for her loss, but I think at this point in time, we're really looking at what Mr. Mueller has done during this period of time and during his probation, and he successfully completed it, everything that's been asked for him, albeit early, and he's simply asking for this early discharge, again, a few months, so that he can meet the duties and needs of his employer. So I would appreciate the court's looking at it in that context. Thank you, Your Honor.
Okay, thank you. Well, the new law that affects all of this pretrial incarceration and probationary terms and conditions, it's just fraught with issues about retroactivity. And I think when it came into effect or shortly before that, many of the judges across the state raised many issues about applying things retroactively. And just to get that out of the way here, I don't know the answers for sure, and no one can tell us that at this point, but I just think it's fundamentally unfair to apply this law in particular retroactively, when clearly under the new law, he would not be eligible for any early discharge, and under the new law, well, he would not be eligible. Since I sentenced him almost 2 years ago, I just think that's fundamentally unfair to apply that kind of retroactivity in this case. So I'm going to apply the law as it existed at the time I sentenced Mr. Mueller. And I too empathize, sympathize, everything you can say with the mom, because this was a horrific assault. It was a memorably horrific assault. I'm sure there were good reasons for the people of the state of Michigan negotiated with the defendant for no more than 12 months in jail. And I went along with it. That's fine. But it was a terrible assault. And I do find it very, very disturbing what the prosecutor told me about Mr. Pretzel. But I don't think, in all fairness, even if we put aside the hearsay and all of that, that I can hold that against Mr. Mueller, even though it is very disturbing. But here we are, almost 2 years later. Mr. Mueller was on a 24-month term of probation. He's asking for a discharge that would be just a little more than 2 months early. Probation, there was a disciplinary punishment part of Mr. Mueller's sentence. Probation is not supposed to be punishment. It's supposed to be rehabilitative. And he's done what I've asked him to do, what I've ordered him to do. It appears from the reports that he's done it, not just to go through the motions, but that he's actually meaningfully engaged in some of these requirements. And I am going to grant the request to discharge him, which is a little bit, like I said, a little bit more than 2 months early. So I have signed your order, Mr. Kraus, that you already sent over in advance, and the motion is granted.
Thank you, Your Honor.
You're welcome. And that will conclude that hearing.
Thank you.
Ooh, what happened? Oh, boy. Okay, there, I had a little malfunction in my Zoom screen. I wanted to unmute. Oh, Mr. Robinson Johnson is now unmuted, okay. And we have Mr. Feigelson back. Hey, Mr. Feigelson, can we proceed on this matter then?
Yes, we can, Your Honor.
Okay, this is People of the State of Michigan versus Devontae Robinson Johnson, docket number 21-351FH. This is the time set for a plea, and we had started this once before, so I assume it's the same thing, which is a plea to count 1.
Correct, Your Honor.
Okay, thank you. And Mr. Robinson Johnson, would you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Thank you. Mr. Robinson Johnson, you have the right to be represented by an attorney. You are represented by Mr. Feigelson. And Mr. Feigelson, if he's pleading to count 1, will you waive reading of counts 2 through 5?
Yes, Your Honor.
Mr. Stevens, would you read count 1, please?
Thank you, Your Honor. People of the State of Michigan versus Devontae Robinson Johnson, docket 21-351FH, State of Michigan, County of Ingham. In the name of the people of the State of Michigan, prosecuting attorney for this county appears before the court and informs the court that on or about the date of March 8, 2021, at or near the location of Isbell and Martin, which is in the city of Lansing, Ingham County, the defendant did in count 1 intentionally discharge a firearm from a motor vehicle in a manner as to endanger the safety of another, contrary to state law. This offense is known as weapons, firearms, discharge from a vehicle. It is a felony punishable by 10 years and or $10,000, mandatory forfeiture of weapon or device. And this offense was done against the peace and dignity of the people of the state of Michigan.
Mr. Robinson Johnson, you're being charged here with discharging a firearm from a motor vehicle. That is a felony punishable by up to 10 years in prison. If you were on parole, there'd be a mandatory consecutive sentence. Have you had enough time now to talk about this charge with your attorney?
Yes.
Do you understand the charge against you?
Yes, ma'am.
Do you have any questions about what we're doing?
No,
How do you want to plead?
I plead guilty.
If your plea of guilty is accepted by this court, it means you won't have a trial of any kind, and you'll be giving up the rights that go along with a trial. That means you're giving up your right to a trial by jury. If you didn't want trial by jury, trial by judge. You're giving up your right to be presumed innocent until proven guilty and to require the prosecutor to prove your guilt beyond a reasonable doubt. You'll give up your right to have the witnesses against you appear at the trial and to be able to cross-examine them, as well as your right to have this court order any witnesses that you might have to appear at the trial. You'll give up your right to remain silent at the trial and not to have your silence used against you, or if you wanted to, your right to testify at the trial. Also, there's some things that are different about appeals when you plead guilty. One is that you don't get an automatic right to appeal your case to the higher court. Instead, you'd have to ask them to hear it, and they would have to agree to hear it. The other thing that's different is if you plead guilty, there are many issues you simply can't appeal. That's different from people who go to trial. If they get convicted, they can appeal pretty much everything. Do you understand those rights, Mr. Robinson Johnson?
Yes, ma'am.
Also, if I accept your plea, it means you cannot come back later on and try to say that the plea was the result of some promise or threat that no one told me about today. Do you understand that?
Yes, I do.
It also means you can't come back later on and try to say that it really wasn't your own choice to plead guilty today. Do you understand that?
Yes.
Mr. Stevens, is there a plea agreement?
Thank you, Your Honor. There is. The defendant will be tendering a guilty plea to count one. Upon successful plea and sentence to count one, the people will move to dismiss the balance of the information. Additionally, the parties have entered into a sentence agreement in this matter, specifically that the defendant's minimum sentence shall be fixed by this court at 24 months. That is to be served concurrently with his current MDOC sentence, which was a probation violation out of Eaton County. That has an earliest release date of March 17th of 2024.
And Mr. Feigleson, is that a full and complete statement?
It is, Your Honor.
And Mr. Robinson Johnson, is that your understanding of the agreement?
Yes, ma'am. I understand.
Do you agree with it?
Yes.
Now, there's an agreement about your sentence, and that is that it would be a MDOC sentence with the fixed minimum of 24 months. You understand that?
Yeah.
And it would run at the same time as the sentence you're currently serving. But if I decided for some reason not to go along with the 24 months, I would tell you before I sentenced you, and I'd give you a chance if you wanted to take back your plea and start all over. You got that?
Yes, ma'am.
Has anyone promised you anything else that has not been said here right now in order to get you to plead guilty?
No, ma'am.
Has anyone used any threats?
No.
Is it your own choice to plead guilty?
Yes, Your Honor.
And are you pleading guilty because you believe you are in fact guilty of this offense in count one?
Yes.
Okay, we're talking about the discharging a firearm from a motor vehicle. Tell me what you did on or about March 8th of this year.
I discharged a firearm from the passenger side of the vehicle.
Okay, did you discharge it on purpose?
Yes.
And were there people in the area?
No.
Were there houses in the area?
Yes.
Were you potentially endangering the safety of other people by doing that?
Yes.
Okay, and did that happen in the area of Isbell and Martin Streets in Lansing, Ingham County?
Yes.
Has the court complied with MCR 6.302, Mr. Stevens?
You have, Your Honor. Thank you.
Mr. Feigleson?
You have, Your Honor.
Are you aware of any promises, threats, or inducements other than those already placed on the record, Mr. Stevens?
None, Your Honor.
Mr. Feigleson?
None, Your Honor.
The court finds the plea is understandingly and voluntarily made without undue influence, threats, or promises of leniency. It is an accurate plea supported by the testimony. The plea is accepted. I have a sentencing date of Monday, August 30 at 2:30, if that works for you, Mr. Feigleson.
I believe I'm here for 3 o'clock, so that'll work.
Okay, good. Then, Mr. Robinson Johnson, I assume it's okay with you if I do a remote sentencing from the prison rather than transporting you all the way to the courthouse. Is that all right with you?
Yes, ma'am, it's fine.
Thank you. I appreciate that. So that'll be on August 30th at 2:30. And there will be an interview that someone will conduct with you. I don't know if they do it with someone at the Department of Corrections or how they're going to do it, but the probation department will have an interview set up where they talk to you and learn more about you, and they put it in a report that I use for sentencing. So you should just be aware that that's going to happen. Okay? Do you have any questions, Mr. Robinson Johnson, before we go?
No, thank you. I'm all good on my end.
Very good. Glad to hear it. Then you can tell them there you're all done with your hearing.
All right.